Chief Justice Malaba has just left. He's now former Chief Justice Malaba, and Chief Justice Gwaunza has just taken over as the head of our judiciary. And I think that's a very important window into some of the changes that we are getting from Amendment Bill number 3, because there may be many, many things that we'll remember Chief Justice Malaba for. Personally, I'll remember him as a great writer, a profound jurist, um, whose judgments were always wonderful to read, and it's very rare. I have found it's very rare to actually find a constitutional judge who always infuses his judgments with a vision for the constitutional court. A constitutional vision for the country is one of the main reasons why I enjoyed reading his judgments. But I also enjoyed what he did with those judgments. If you read the Chimakure judgment, the Mahia judgment, when he was dealing with, criminal defamation, with criminalization of publication of falsehoods. There have been some very important judgments from him, including, of course, the Mudzuru judgment to deal with child marriages. And in Chimakure, I'll always remember his description, of freedom of expression is including an internal dimension, an external dimension, but he had 3 dimensions. He actually broke down the meaning of expression. Very, very erudite, and someone who had real technical expertise that he clearly enjoyed to write. Not only when he was a Chief Justice, but even when he was Deputy Chief Justice, he would write a lot of these judgments. Very lengthy, very, I think the Chamisa judgment is 132 pages. I always enjoyed reading his judgments. But that's just my memory, right? At least not memory, but what I'll remember is his legacy. But that's a long way to summarize the legacy. We've had how many? Maybe 6 Chief Justices. Let's not mention Hector MacDonald just after independence. Most of us remember the first Chief Justice as though it is Enoch Dumbuchena, even though he was the second post-independence Chief Justice. But when we think of Enoch Dumbuchena, most of us, I think, we think about Black excellence, since he's the first Black Chief Justice, or African is the way calling it, in the pre-colonial into post-independence period. So we think of Black excellence. We think of his willingness to confront the executive. Quite famously, when the executive would not, when it withheld the salary of former Prime Minister Ian Smith because of his scathing attack of the post-independence government whilst he was abroad, and the court said you couldn't do that. As well as some very big human rights cases. So we think of Black excellence, but we also think of, separation of powers, human rights. And then when we think of Anthony Gabe, just as we think of Chijausiku, those Chief Justices, we generally think about land, right? Even though we would associate Gabe more with rights, but with Chief Justice Chijausiku, we think more central about land. And even in his own exit interview with the Herald, he really foregrounded land as what he thought was central to his own legacy. And then with Chief Justice Malaba, I quite understand many people might associate him with this new jurisdiction we gave the Constitutional Court to determine presidential election petitions. So many people may associate him with the Chamisa presidential election petition. Others may think of him in the context of children's rights, child marriage is the age of consent, the Mudzuru, Kawenda sort of judgments. I tend to think of Chief Justice Malaba as the first and last Chief Justice in Zimbabwe to be appointed after a public interview process. And that really distinguishes him and how he handled the relationship between the judiciary and the people, and I will show how. And the current Chief Justice and perhaps Chief Justices after him do not seem to have that same relationship because they have not been appointed through the same process, right? In this case, it's simply the president just, he just releases a letter, he just announces, I have chosen, this is my Chief Justice. We no longer go through the elaborate process that we had in 2013. So in a certain way, Chief Justice Malaba is exiting together with the promise of the 2013 Constitution for me. The promise of a constitutional court. I'm going to show in this discussion how we are losing a constitutional court. We are losing that conception of having a unique institution, a specialized institution that is simply established to defend the Constitution. We are losing that conception of constitutional supremacy as something enforced by the highest court, and that is kind of drifting. It's migrating towards the legislature. And overall, we are losing the conception of judges as people who derive their authority from the people. We are losing that constitutional conception, which we still have, right? Judicial authority is still derived from the people, but this amendment is gutting all the ways in which that authority is derived from the people. So that is section 162, which I'll continue to come back to, which says judicial authority derives from the people of Zimbabwe and is vested in the courts. So other constitutions will simply vest judicial authority in the courts. In Zimbabwe, it actually derives from the people and vests in the courts. And then they and I believe we are losing that. We are losing the ways in which that authority is derived from the people. Excuse me, I'm just going to take a sip here. And if you've listened to some of the people who are defending the amendment bill number 3, they will argue that, well, judicial authority, it derives from the people. Even the president, they've said the president's authority derives from the people, but you don't need to directly elect. Hey, look at the judges. You don't directly elect them either. So why are you raising this noise about the president? And in Zimbabwe, the judicial authority is derived in a different way because it is not conceived in the constitution as an elected office. In other places, it is conceived as an elected office, right? Over 30 US states, perhaps 37 US states have got judicial elections, which were established during the Jacksonian revival in the early 19th century. So a lot of people in the United States do vote for their state level judges, particularly the Supreme Court and at other levels. So over here, judges do engage in campaigns. They just don't do so at the federal level. Mexico just made all judges elected offices recently as well. In a few other countries. So there are countries in which deriving authority from the people means you actually get elected. The judges actually speak for the people. It's not very common around the world because people conceive of judicial independence as something that is central to the function of the courts. Therefore, people do not want campaign issues to have a direct bearing on how judges actually rule on matters. So it's not that common. But the question is, how then is the authority derived from the people if the Constitution tells us that judicial authority is derived from the people? And we'll get a clear sense of how that authority is derived from the people if we read Section 180. And if you look at Section 180, it says that whenever it is necessary to appoint a judge, and I'm going to read here the 2013 version, and then we'll go through how it was amended. But certainly in 2013, how is a judge appointed? Whenever it is necessary to appoint, the JSC, the Judicial Service Commission, has got the obligation to advertise for the position, right? So whenever there's a vacancy, number one, everybody gets to know about it. So how is the authority derived from the people? First, it is knowledge that there is a vacancy, right? We don't just wake up and are told that somebody is appointed. No, we have to be told there's a position that is open here and we're looking for somebody to fill the position. Then secondly, the Constitution says the JSC must invite the president and the public to make nominations. Now, this is very important, Section 180, subsection 2B, because you're not going to find in any other constitution, at least in my search, where the public, you and I, are given a role in nominating a judge. Other countries do it as well, either out of practice or out of statutory law, right? An act of parliament may state that. But in Zimbabwe, we put it in the Constitution that you and I, as the public, as the people, as the VNA, we can nominate. So when the Judicial Service Commission says there's a vacancy for the Chief Justice, Deputy Chief Justice, Judge of the High Court, Administrative Court, you can send in your nomination. I nominate such and such to sit as a judge on the court, right? And then, of course, that person has to then give a response. Do they accept the nomination to be considered or not? But that is foundational. Do you see how authority is being derived from the people? It is not just the president that nominates. As in here in the United States, the president nominates and the Senate confirms. You see, so it's It's a sort of co-equal role between the executive and the upper body of the legislature. In Zimbabwe, everybody gets to nominate the judge. Everybody gets to nominate the judge. And I want to talk later about why we want everybody to get a chance. Everybody gets a chance, right? It's like the FIFA World Cup. Everyone gets to participate in the qualifiers. There has to be some way for you to actually end up. At least you say, I participated in some form, right? This World Cup tournament. Everybody can nominate. It's not just the president, not just the Judicial Service Commission. This is where the power is derived, right? The people can vote for their president, they vote for their members of parliament, and they nominate their judges, right? They nominate their judges. So this is the people actually participating in how the judiciary is constructed. And then thirdly, the Judicial Service Commission, this is 182C, must conduct public interviews of prospective candidates. So do you see, first we must know that there's a position. Second, we get to nominate. And thirdly, we get to monitor. We get to monitor. Hey, I'm watching the interviews. I nominated this fella over here. I nominated, I don't know, Morgan Mugabe, as BT used to put it. I nominated Morgan Mugabe to be part of these candidates. How come they are not part of that, right? So you have a role not only in knowing, in nominating, but in monitoring, right? So you are not just a passive spectator. This is the whole point. You get to know, you get to nominate, you get to monitor. And then after that, the Judicial Service Commission prepares the 3 qualified persons submit to the president. If the president is unhappy, they get to submit another list. And then the president appoints. So in a nutshell, the way that judicial authority derives from the people is in the fact that people get to nominate. They're not only aware of the vacancy, they nominate, they monitor the process of appointment. And then the president, who is elected by the people, gets to appoint. So the people nominate, the people monitor, the president appoints on their behalf. On their behalf, because the president has got a popular mandate. This is how the president, so both the president and the public are nominating, right? The president and the public are also watching as the Judicial Service Commission conducts interviews. And then the president gets to receive this list and then appoints on behalf of the people. So what happened to what I think is a very beautiful and elegant structure? Well, what happened was when Chief Justice Gwaunza, the late, retired, and the process began to appoint the next Chief Justice, what proceeded, and everything I'm going to say here is a summary. If you want a blow by blow for how this happened, I'm going to put a link to the article that I published together with Professor Joe Felto on Playing Politics with the Judiciary, explaining precisely this episode. Because once the Judicial Service Commission began this process of advertising, then the executive, through the Justice Minister, who is now the president, right, representing a faction of the party that would later establish the Second Republic, told the judiciary, whoa, right? Hold on, Pulo, you don't get to do that. We in the executive are planning to amend this process. So please stop. Do not advertise. Do not conduct interviews. And Chief Justice Gwaunza publicly expressed the really weird position into which he was placed, that the Constitution requires him to do something, and the executive is inviting him to violate the Constitution by ignoring it. You don't do what the Constitution says. So what are we supposed to do? There's a vacancy. Of course, we're going to have the vacancy and the interviews. So they actually secure a high court order, right, through a law student who was a law student at the time, Romeo Zibane, to stop the public interview process. And it is the judiciary itself, right, which had to appeal that decision, to suspend that order, to conduct the public interviews, in spite of active and public resistance from the executive. So this is why at the time, Chief Justice Malaba, he participates in the interviews, he scores the highest in the interviews. And so there's a public-facing way in which Chief Justice Malaba is justifying why he must be Chief Justice. Because it's pretty clear that he's not the preferred candidate of at least that faction of the ruling party, right? And eventually, because Malaba actually comes to the public, and the public gets to see him, right? He gets to demonstrate and justify why he believes he must be the Chief Justice. And then in the end, he is appointed. He is certainly the most senior. But but what happens is the Chief Justice is appointed after that public interview process, and then they change it, right? And then they change it. But I want people to, and I think I'll put a link to this below. That I think we've all seen the speech by the new Chief Justice. And by the way, I probably forgot to say congratulations to her. I'm very happy with her appointment, and I'll also explain why I am. But if you look, I want you to look at the video when Chief Justice Malaba is appointed the Chief Justice, and how he frames his own position upon appointment, when he is saying, we have shown today that we respect the rule of law in Zimbabwe. And the rule of law is what I'm telling you about, that the courts had been told, hey, stop. And then the courts say, we have to follow the law, the constitution. So he says, we've shown that we follow the rule of law. But then he says, we've also shown that we respect the people's wishes. Very, very interesting, right? So the Chief Justice is saying, my appointment shows that the government respects the people's wishes. Which people's wishes was he talking about? It is this concept of deriving authority from the people, that that entire process of the candidate presenting themselves to the people, right, and showing why, and the Judicial Service Commission then acting based on your presentation, that is grounding the judge in popular legitimacy. And then he says after that, former Chief Justice Malaba, that, so I want to thank the people of Zimbabwe who saw it fit to appoint me through the president acting on their behalf, right, as the appointing authority. So you see how he's thanking the people. And if you listen to Chief Justice Gwaunza, she cannot say that. They've taken away that entire ability. So you see, when Ruben Barwe is asking Chief Justice Gwaunza about perceptions about judicial capture, she does not have that ability to say, judicial capture, we had an open process, open and transparent. People could nominate, and people got to watch the interviews. They know for themselves. They watched. And so this is actually respecting the people's wishes. That's why we have it in that sort of open interfacing manner. She could not say that. The only thing she could say was to go doctrinal and say, don't listen to the people, just stick to your training, just do the right thing. Someone will always be unhappy because the court has to establish winners and losers. So it's been de-linked from the people that way. And the delinking began with the First Amendment, when it was determined that the Chief Justice, the Deputy Chief Justice, and the Judge President will be appointed after consultation with the Judicial Service Commission, which is to say that the president gets to pick whomever they want, but if they're unhappy, they report to the Senate. And you have to also ask yourself, in terms of the First Amendment, why is the president reporting to the Senate? Because we still gotta know, right? It's about public accountability, public facing. The fact that the appointment, if it does not fall in line with the employer's recommendation, we must know that, oh, this is just the president doing whatever he wants. Not Constitutional Amendment number 3 bill has taken away that reporting requirement. There is no longer a requirement for the president to report to the Senate, which requirement was there even in the Lancaster House Constitution as amended. In the pre-2013 era, if President Mugabe had appointed a judge contrary to the Judicial Service Commission recommendation, he had to report to the Senate. He had to report to the upper house of the legislature that represents the people. That has been taken away. That has been taken away. And yet, but that was the First Amendment. That, well, for the top judges, the argument was that we don't want the Chief Justice to be interviewed by the Chief Magistrate and ordinary High Court judges in the Judicial Service Commission. So it was like, we don't want seniors being evaluated by juniors. And look at how weird that that entire argument is. Because the entire idea of democracy is based on seniors being evaluated by juniors. When the president comes back to the election, the ordinary person is evaluating the president. That is the whole idea of the people. But they decided to entrench this structural distinction between the ordinaries and the extraordinaries. The ordinaries cannot evaluate the extraordinaries. Therefore, for these ones, we just want the president to act. And so they got the First Amendment. But then they proceeded in the Second Amendment to say, well, even for the judges who are already in the judiciary, we no longer want public interviews when there's a vacancy. And their justification was the fact that in many jobs, some jobs, not all jobs, once you get your position, after your initial interview, promotions to the next level do not require more interviews. Sometimes you can just have a performance appraisal and the employer will simply say, okay, we think you're good enough to become now a manager, to become, some jobs will certainly do that. It wasn't the case at the job I'll tell you that. I was at Lawyers for Human Rights for like, I don't know, how long was that? 9 years. And then when I said, I don't really feel like I've got prospects for career advancement here, they were like, well, actually, your manager just left, so feel free to also apply because we are floating that. I was like, apply? I've been here 9 years. You're going to tell me to apply? I'm gone. I hit the road. So it ain't every employer who's just going to be like, I promote you, right? Some employers are like, go for interviews. And that was the Judicial Service Commission. You want promotion from, I don't know, you from being a magistrate to a judge, from an administrative court or labor court judge to a high court judge to Supreme Court judge. Apply with every other candidate. But they changed that. Promotions within the judiciary, in the Second Amendment, those could occur on the recommendation of the Judicial Service Commission. The Judicial Service Commission argued that we are the employer, we can give the appraisal, and these promotions, like the most recent ones we heard about, high court judges that were promoted, that is the president acting on the advice of the Judicial Service Commission. So in that context, the president is actually very, very limited to having to act on the advice of the Judicial Service Commission. And then now the Third Amendment is removing all that. It's removing all that. The president does not need to act on the recommendation of the Judicial Service Commission at all. Not for promotions, not for the judge president, the deputy chief justice, the judge president, the chief justice, not for those senior ones, not for any. The president can simply appoint any person to the bench who meets the qualifications. Whether or not the president is following the advice of the Judicial Service Commission, they do not need to tell us. So it is possible. I would argue it is highly likely in this instance because there is no indication that there's no indication that there will be a report submitted to the Senate that the president did not act on the advice of the Judicial Service Commission. And certainly, like I said, Chief Justice Gwaunza was the Deputy Chief Justice. She was the most senior. So her appointment is, of course, proper in that way, the most senior judge. And then I'll talk about whether it always follows that way. But I'm just saying, when the question arises about judicial capture, I think the proper way to engage it would have been that these interview processes are there to deal with that. And once you remove them, this is what foments the idea that these are no longer the people's judges. They are no longer the people's courts. They are the president's courts, the president's judges, because the president simply gets to decide.